Mr. Speaker, pleasure to be here with you to open debate on third reading on what I think members across this room and Canadians across this country have concluded is a long overdue updating of a great Canadian institution, citizenship. It's a good bill with a huge number of positive provisions that are going to give better service to permanent residents on their way to citizenship, to citizens themselves, and literally lift up to an even higher level that sense of pride that we all take in our citizenship as Canadians. I'd like to begin by thanking many of my colleagues who labored long and hard on this bill. That work began long before I occupied this portfolio. I'd like to salute my colleague, the Minister of Employment and Social Development, who really brought this bill in most respects to its current stage. Also my Parliamentary Secretary, who's done fantastic work in committee and here, as well as many members of Parliament. Member of Parliament for West Vancouver, Sunshine Coast, Sea to Sky Country. Very important work on the issue of lost Canadians and on citizenship generally. Member for Calgary Northeast, who's tapped into a particular facet of that pride that Canadians take in their citizenship in introducing measures in this bill that will make sure that gross crimes of disloyalty, when committed by dual nationals, result in revocation of citizenship. Mr. Speaker, in the time available to me, I'd like to cover 4 quick items. First, to respond to our critics, to respond to those who have misunderstood the bill or disagreed with the bill in one way or another. We are listening. And secondly, to talk about where this bill takes our citizenship in the 21st century, what is at the core of the value of Canadian citizenship that is reinforced by this Act. Then I'd like to remind the House what the main aspects of the bill are before concluding with some forward-looking comments about the impact that this renewed pride in citizenship can have, above all on young Canadians, but on all of us across the country. First of all, on the questions that have arisen in the media, in this House and elsewhere about the bill. There have been a few lawyers, there have been a few voices in this House questioning the need to require those applying for citizenship to declare their intent to reside. The bill in section 3(1)(c)(1) asks that the applicant be required to intend, if granted citizenship, to continue to reside in Canada. And some have misunderstood this provision to mean that anyone applying for citizenship, anyone seeking to meet the requirements of citizenship, which of course will be 4 years of residency out of 6, must declare an intention to reside in Canada for the rest of their lives. Mr. Speaker, nothing could be further from the truth, and those who have perpetrated this misunderstanding have simply not read the further paragraph, which is at 2(1)(1) on page 12 of the bill as we have it printed. For the purposes of paragraphs 1(c)(1) and 11(1)(d)(1), a person's intention must be continuous from the date of his or her application until they have taken the oath of citizenship. So, Mr. Speaker, the intention to reside that we are requiring, which we wish had been required in the flawed 1977 version of this bill, relates to the period of physical presence in Canada, residency in Canada, required to become a citizen. Because that has always been a requirement to become a citizen for 100 years, Mr. Speaker. It was in June 1914 when formally a 5-year residency requirement was put in place. That was watered down by the Liberals under Pierre Trudeau in 1977. We think it merits increase to 4 years, 4 to 6, but with a declaration of intent to fulfill this requirement. And why, Mr. Speaker, is it important that we secure that declaration of intent? Because not just in Canada, but around the world, many people, not a few people, consultants, lawyers, have sought to misrepresent this requirement and to argue that residency in Canada did not require physical presence here, did not require the intent to actually be here. And hence we have this large backlog, overhang of abuse the RCMP is investigating that leads to revocation of citizenship. We need to send a clear message. Residency will mean henceforth with this bill, 4 years out of 6, a physical presence in this country, and we will require applicants to declare it over the period from submission of their application to the day when they take the oath of citizenship. But let me remind this House, nothing in those provisions constrains the mobility rights either of a permanent resident or a citizen. Someone can have the intent to reside, but then their plans change. They move elsewhere, they don't fulfill the requirements of the residency requirements for citizenship, they don't become a citizen, perhaps until later in their life. After they obtain citizenship, of course, Canadians are free to do whatever they want as citizens. Secondly, Mr. Speaker, on revocation. It's extraordinary to us on this side, and I think extraordinary to Canadians, that so many opposition members would have expended so much breath opposing the revocation of citizenship only from dual nationals for crimes like terrorism, treason, taking up arms against the Canadian forces, espionage, when we already revoked citizenship for much lesser crimes, for the crime of having concealed a criminal record, for the crime of having obtained citizenship fraudulently. We, Mr. Speaker, take our responsibilities with regard to revocation extremely seriously. Every one of these paths to revocation, cases of revocation, involves judicial oversight, involves recourse to a court. There is judicial review available explicitly in the bill to every aspect of this bill. And yes, if citizenship is to be revoked based on a conviction for terrorism, a file would be prepared for the minister would review it, the person would be given notice, be invited to make written submissions, there's provision for a hearing. But Mr. Speaker, this review doesn't begin until a court has convicted the person of this crime. And I don't need to remind members in this place of how few convictions, fortunately, happily, there are in Canada, or of Canadians for these very serious crimes. This is a provision, the additional revocation provisions in this Act, that is well understood by Canadians and well accepted by them. With regard to membership in an armed group fighting the Canadian forces, the minister would not be able to take any action actually without going to the federal court at the very outset, bringing facts and evidence that the Canadian citizen in question had been engaged in armed conflict and satisfying the court that that was the case. That's the only way to even start this process. And of course, if the rules of evidence, if the case do not allow, if the case is not strong enough, then it won't make it through the federal court and revocation won't take place. So these measures are being undertaken within the framework of our very robust judicial institutions, the rule of law in this country, and everyone should celebrate the fact that they will constitute a very profound deterrent, not just to younger generations, to all Canadians, and a reminder that allegiance and loyalty to this country require that these grave crimes be avoided at all costs, and when they are committed, be punished. These were, Mr. Speaker, the two grave weaknesses of the 1977 Act. The failure to obtain a declaration of intent to reside from applicants, and secondly, the neglect of issues of loyalty and allegiance. Liberals did not make this mistake in their 1947 Citizenship Act, which actually provided for these measures. Conservatives didn't make these mistakes in our 1914 Naturalization Act, which 100 years ago, which set us on the course, towards the strong citizenship that we have today. And certainly, Mr. Speaker, our NATO allies, our closest partners in war and peacetime, the other leading democracies of this planet have not at any time made this mistake.
True.
And I remind this House that there's only one NATO country according to our analysis, that doesn't have revocation provisions equal to or more severe than the ones we are proposing in this bill. Secondly, Mr. Speaker, where is citizenship today in Canada? What does this bill give us? What does it strengthen for us that perhaps wasn't there before? Well, here I think the key provision relates to residency, relates to the attachment, the connection, the experience of Canada that we're promoting with this bill, which heretofore newcomers to Canada have actually told us in large numbers was not strong enough. The knowledge test, the language test are part of that, but there is no substitute, Mr. Speaker. I think all of us have heard from immigrants, newcomers, those looking for jobs, those who started careers here, those looking back on what their forebears went through. There is no substitute for direct experience of this country, and 4 years is a legitimate minimum for what that experience should be. What happens to permanent residents and Canadians, future Canadian citizens over those 4 years? They discover this country. They discover 10 million square kilometers. They discover its diversity. They discover how the rule of law works here. They discover our institutions. They discover why our economy is prosperous, why our agricultural sector is the third largest in the world, why we have manufacturing and technology burgeoning in all parts of this country. And they find their path into that workforce, which need not just involve natural resources, manufacturing, or agriculture. It could be cultural industries, Mr. Speaker, one of our fastest growing sectors in this country. So 4 years ensures that the old adages about the Trudeau-era standards of citizenship, that citizenship was a citizenship of convenience, former member of this House called it that Canada was just a hotel where people checked in and checked out, passport in hand. Richard Gwynne spoke about the unbearable lightness of being Canadian. People could come and live and benefit from citizenship, but they weren't asked to do much more. We have been reminded, Mr. Speaker, at every stage of our 8 years in government, that new Canadians, new citizens, new immigrants want more. They want to understand the history of this country. They want to understand where the success comes from, and they want to belong in that deeper sense. And the value of Canadian citizenship, as reinforced by this Act, will help them to do exactly that. Thirdly, Mr. Speaker, what are the core what are the improvements that we're delivering in this bill? The first is about service. Because of high immigration, 260,000 almost over our 8 years in government per year, the highest sustained levels of immigration in Canadian history, because of our high rate of naturalization, because people who become immigrants want to become citizens, want to make the extra sacrifice of improving their language skills, mastering the Discover Canada Guide, taking the test, and living here, just literally discovering Canada by living here, we do have a backlog. And the backlog is a little bit larger because of the abuse and the residency fraud that took place that slowed down applications as we had to come to terms with which was a legitimate application and which one, unfortunately, was not. With the measures in this bill, and actually with measures undertaken in previous budgets, we have the resources and we will have the decision-making framework to move through that backlog quickly, to take a processing time of 2 to 3 years for new applications today, down below 2 years in the course of next year, 2015, and to under 1 year by the beginning of 2016. Secondly, Mr. Speaker, we're reinforcing the value of citizenship. I mentioned that. The residency requirement will get longer. Thirdly, we're giving ourselves new tools to ensure that fraud is a thing of the past, if we can possibly make it that, in our citizenship programs. We will be much less vulnerable to residency fraud. We will regulate citizenship consultants to make sure they cannot lead applicants astray, as we have done with immigration consultants and increasingly with immigration lawyers. We will also raise the penalties from $1,000 to $100,000, from 1 year to 5 years imprisonment, potentially, for the forms of fraud and misrepresentation that unfortunately have been all too common in our citizenship program. Finally, Mr. Speaker, we deliver on our commitment across all of our programs to honor those who serve. Those who wear the uniform, RCMP, military, abroad, those who work in embassies, as I had the privilege of doing, will be able to pass on their citizenship beyond the first generation, even if their children are born outside of Canada. And new Canadians, permanent residents who are members of the Canadian Forces, will have a slightly faster pathway to citizenship, 3 years instead of 4. So what does our citizenship look like in the 20th century, Mr. Speaker, 21st century? It will have less fraud. There will be more penalties. It will be a much more prized citizenship. And because of all these things, Mr. Speaker, we will be properly able to say, we Canadians are in a position to promote our citizenship, to use our citizenship as never before. It will be something that those outside of Canada seek to acquire with more determination than ever, and it'll be something that those of us in Canada who have it will be seeking to use as never before in the world, to do good in this country and to do good in places not so fortunate. It is our citizenship, Mr. Speaker, that lets us undertake the kinds of initiatives our Prime Minister has been undertaking for maternal, child, and newborn health. It is our citizenship that allows us to take action on child, early, and forced marriage. It is our citizenship that lets us be one of the second most prominent country in the world for refugee resettlement, accepting roughly 1 in 10 refugees resettled every year in cooperation with UNHCR, including those now coming to us in ever greater numbers from Syria. But Mr. Speaker, our citizenship also lets us work towards building the economy of the 21st century. It was interesting that the OECD report released this week on Canada gave a prominent place to immigration reforms and indeed to the naturalization rate in Canada and the citizenship program that we consider part and parcel of our immigration programs, arguing that without these kinds of programs modernized to meet the needs of the 21st century, it is not possible to match specialized skills, more specialized skills than ever, to the needs of a changing economy. And because of our prosperity, the Canadian economy is changing faster than almost any other. It was interesting to read that the OECD sees immigration policy as an economic driver and speaks of Canada in relatively glowing terms because of the extent of our immigration reforms over the past year as a pioneer and an innovator in this field. Mr. Speaker, we have been citizens of this country, all of us, from day one. From the day we arrived here and from the day we met the requirements, it's vital for new generations of citizens to see this great institution of citizenship protected, to see where it comes from, to understand what it was in the time of Nouvelle France, what it was at the time of the War of 1812, what it was for those who stormed Juno Beach on D-Day, what it was in 1914 on the eve of the Great War. We will have many occasions, Mr. Speaker, to celebrate our citizenship in the next few years in the run-up to the 150-year anniversary of Confederation. I know all of us on our side look forward to celebrating them with you and all Canadians. Thank you.